Welcome back to the Legal Alternative Podcast with Sam and Nils. Nils, how are you?
I'm good, Sam. I'm not liking this unseasonably cold weather, though.
It is. Hope for getting better next week. What have we got coming up, Nils?
Yep, so we're going to, usual format, what we've got in our inbox. We've got a very, I was going to say very special. It is a big anniversary that we're going to discuss in what's been happening out of the office, and then hopefully an interesting question that a listener has emailed in.
Yeah, I'm going with the update this week in terms of what's in my inbox. Don't know if you saw, Nils, national minimum wage reporting in terms of naming and shaming came out. So we've both done a bit of work in. And what I wanted to talk today is I think you probably agree that when we've dealt with these breaches, most of them are technical. It's not, an attempt by an employer to pay less than minimum wage. It's often caused by technical issues, whether that's a deduction one, or the thing I wanted to talk today about was TOIL and the impact of time off in lieu on the national minimum wage. So for listeners who aren't aware, TOIL is a practice where employees work over their standard hours, and rather than being paid overtime or additional remuneration, are given time off instead. So they have work additional hours, and then maybe at a later date they take some time off, which obviously then is paid. The problem we are running into with national minimum wage, and I think it's becoming obviously more common now that the living wage has increased so much, and the real problem is not with employees who are hourly paid, but people who are on a salary that is close or on national minimum wage. So technically, TOIL is not recognised under the national minimum wage regulations. And the trouble that clients and people are running into is where we are having a process where perhaps additional hours are worked 1 month, and then in the next month, time off in lieu is taken. Because how the national minimum wage calculations work are in relation to what we call pay reference periods. And that again is dependent on how you're paid, but the real issue in the technical breaches seems to be for monthly salaried employees. So the problem we're getting is that in 1 month, employees work over their hours, and then that works out what their minimum wage would be. They're then taking the time off in another month, or where then their hours are reduced, but then we're not having in one pay reference period suitable amount of pay for the work done, because obviously in the first month they've worked over their hours but only been paid the same because they get the benefit in the next month of the time off. So for the first month, that pay reference period, they won't have met the minimum wage calculations for that month. So where we say it's a technical breach, because look, viewed over a year, they will have been paid and their salary is as much as the national minimum wage. It's in that month period where they work more that there is that technical breach. So that again has caused some problems, and wherever we're seeing this often happens seasonal work. So where people are salaried but may for some either that's a summer fruit picker or a retail in the winter where you have obviously busy periods. They work more hours in December, for example, but then when it's quieter in January in retail, they're given this time off in lieu. So that does cause real problems, and increasingly so because of the increase. And so more salaried employees are being paid closer to the national minimum wage limit. For the listeners, obviously quite serious consequences. Nils, I think better than most on this in terms of some of your, you've acted on a lot of these in the past. If an employee suspects they have been paid under the national minimum wage, that can then trigger an investigation from an HMRC. Not a particularly pleasant thing, as you'd attest to. And if there is a result of the breach, I'm just looking at in terms of the figures, that can result in a financial penalty up to 200% of the arrears, up to £20,000 per employee. So if this is something that is being done uniformly with quite large numbers of employees, we need to be very serious because there's serious consequences. So if anyone is adopting TOIL still, I think you need to really review those policies. Obviously, if your employees are paid well above national minimum wage, there probably wouldn't be a problem. But, you know, if people are working a lot of hours in a month, you still can get there. Other potential solutions, as long as the TOIL is taken in that same month, we shouldn't have a problem because of the hours should then equate. But again, something that is difficult to see. Obviously, the obvious solution is you pay overtime rather than allow the TOIL. Understand why that's done. A lot of people haven't had this practice of TOIL, but something that, you know, I wanted listeners to kind of keep aware.
As I sit here, I think we've done the mock trial. We almost probably should do a seminar and a mock.
Yeah,
mock inspection on this, because for me, this is the one area of law where I've never ever seen someone do this deliberately.
No.
Every single time I've been involved in, and there's been 3 or 4 very large cases that we've been involved in, and one many years ago in the care sector. I've looked at all of them and thought, you're not bad people.
No.
You just have got this wrong, and there's no reason why they'd know that they got it wrong.
No.
So I think education in this area is a big thing, because unless you sit down and read that national minimum wage pack, you don't know about TOIL, you don't know about uniform deductions, you don't know about travelling time. There's all sorts that comes into it, and it's critical, because if they get the clause into you, they're rightly gonna give a notice of contravention and then name and shame you.
Yeah.
And some of those organisations on that list are huge. This is not all about small employers.
And as I say, going to become increasingly common with those salaried employees being very close to the national minimum wage.
Yeah.
So really good, as I say, for people to be aware of, and obviously any help, quite technical area, both for small and more than happy to help. I think we're on to out of office.
Yeah, some really positive news. It's a member of your team, so I'll let you.
Yeah, that we both know well.
Yes, we do. Yeah,
we do. So, one of my team is celebrating 20 years at Chadwick Lawrence. So to Adele Whitehead, if she is listening, be a good test if she is listening to the podcast. Obviously, fantastic achievement. She supported both of us throughout our career. So we are going out for lunch at the time of recording tomorrow.
Yeah.
So that should be a lovely day. It's a bit of a surprise lunch, but she won't know about it. So by the time of recording, it's on. So no, big thank you to Adele from us both, and it should be a great lunchtime.
Absolutely. My first day at Chadwick Lawrence at the Wakefield office, I walked into the wrong room, and Adele dragged me back into the right room. Her and Carol. So yeah, I've worked with Adele since day one, and we appreciate the support and all the hard work that she does. Absolutely.
Fabulous. In terms of questions, social LinkedIn, I've got a good question, Nils, that's come in. Is it possible to conduct a right to work check for a gig economy worker or employee?
Looked at particular sectors within the gig economy, or in fact the gig economy as a whole, as being more vulnerable to exploitation, to illegal working, to people and organisations who aren't necessarily 100% certain whether an individual has the right to work in the UK or not. So it was actually on the 1st of March that they announced this, so a little while back.
Yeah.
So organisations who do engage with gig economy workers, so off the top of my head, I'm going to be thinking of things like the ones we all know, such as food delivery, healthcare products delivery, drivers, but that type of thing. But the gig economy is actually quite a lot wider than that. So I'm thinking, as you've mentioned, for TOIL, seasonal workers, it is going to be a requirement that you do a right to work check. And there are going to be penalties for failing to do so. Just while I'm on the different types of service, beauty industry apparently, which I didn't think about, and courier services. Penalties for non-compliance. I was quite surprised when I saw this. For a first offence, £45,000.
Wow.
Up to second offence, £60,000 per illegal worker for repeat breaches. Other potential consequences might close the business, power to do that, director disqualification, and if a criminal offence has occurred, imprisonment of up to 5 years. So I think the difficulty that some of our clients may have is that this is going to be quite a big administrative burden in an area where I suspect there's quite a high turnover of staff. But to avoid that type of fine, plus the reputational damage that would come with that sort of fine, that's going to be worth doing. So that onboarding process, and I suppose one of the big advantages previously of engaging a gig worker is that onboarding process was a lot simpler. Now going to get more difficult. So an update from March. I'll keep an eye on that.
Yeah. When I struggle with actually, because I do understand the rationale, and we've talked previously about kind of anti-slavery and exploitation of workforce, and you can see the logic obviously in the gig economy, that there has been cases on it is sadly rife for exploitation. So you can see this shuts it down to a degree, or hopefully if there is penalties and it's enforced, it should hopefully prevent some of that. But completely then see the other side of it with, yet another administrative burden. The final point for me, Nils, and I don't know your views on this, is it's yet again something else that really blurs the line between worker status. Yeah. And I know there has been some talk in the obviously Employment Rights Act potential changes of simplifying this. At some point, it does beg the question, well, what is the point of having more than one status if ultimately, as an employer or someone engaging with workers, you're essentially going to be doing the same tasks that you're going to do for an employee. So for most for employers, I'm guessing, for their induction process for workers or gig economy workers is going to have to amount to what they do for employees. They're doing a right to work check. So at some point you say, well, what is the point?
Exactly.
And it'll be interesting to see where they go.
Develops, yeah. Like you say, I suspect what will come next is eventually you've got to auto-enroll a gig worker. Yeah, I just think it's going to be that natural evolution.
Yeah, and perhaps, again, there will be some frustration, but perhaps that is sensible, that you just have an employee worker, call them what you want, and someone who's self-employed, whose responsibility is to do all of that themselves. Yeah. Simplification would seem to be sensible, but absolutely. At the moment we are where we are, so as always, we'll keep
everybody abreast of that.
Everyone abreast of that. And that's it for this week. It's been two interesting topics that we both, good ones that we both deal with a lot. So some great updates. We'll be back next week. So bye from me.
And from me.